Welcome back to Justice Redesigned. I'm Steve Teskey, retired judge, and your host. Now, I know we have beaten the bar card series to death, but I cannot help the fact that the series has been extended by the shenanigans of interim Attorney General Todd Blanche. And the best way I can describe it is his comedy of errors in trying to push through an anti weaponization fund to use the hard earning wages of citizens, that is our taxpayer money, pushing them into the pockets of those who attacked the Capitol on January 6th and destroyed government property, committed acts of terroristic threats, assaulted police, and more. And many of them were convicted. Many of them, most of them pled guilty. They said, I'm sorry. Many of them cried before the judge. I'm so sorry I did this. And then now we're finding out, right, that many of them are recidivating and committing crimes after they've been pardoned by the president. Well, I'm not shocked. Okay, not surprised at all. But it's not my fault that my prediction in our recent episodes that Blanche would be facing disciplinary actions as soon and as the moment he leaves office. I didn't know it would come sooner. Okay, while he's still in office. Now, the connection between our bar card series and the news that Blanche is facing a complaint in the New York bar system, and by the way, get this, filed by 101 former judges, federal and state, is like too strong to ignore. Now, I wrote an essay, if you read it, that is, titled The Reckoning of the Bar Card, 101 Judges File for the Disbarment of Acting Attorney General Todd Blanche. And I got that out right away as soon as the news hit because it was just so important. I just had to get it out and make it timely. But it's the first part essay that, together with part two, concluded the Bar Card series. Now, this podcast breaks down the part two essay, and it's called The Illusion of Precedent: Bipartisan Rage and the Ultimate Check. You can go on my Substack account and cite and read it, which will finally bring us to a close, unless, of course, something new happens. And then at that point, it's not part of the bar card series. This is going to be an update. Okay. But I'm not completely repeating myself in the essay and in this podcast. To some extent, I am to lay a foundation, but there's some new things I'm going to be sharing with you. We take on an entirely different topic, or may I say, strategy that was employed by Todd Blanche that has not been shared in this series to date. And I think that's the best way to conclude this. Now, with all that said, to set up this show for you, let's move on to the story itself. Now, normally, or on the most part on this show, we talk about the law with, some high degree of judicial solemnity, okay? We talk about constitutional frameworks, Article 3 standing, and the rules of professional conduct. But today, we have to talk about Todd Blanche's out-of-court settlement with the IRS. Now, I've already talked about it in some respect, but in this regard, there is something that he employed, a strategy I have not talked about yet. Okay. And folks, I got to be honest with you. As a former judge, looking at this case with judicial solemnity is like trying to review a three-ring circus by analyzing the structural integrity of the clown car. Now, stay tuned to hear about the circus. We'll be right back. Welcome back. So let's put the robes aside for a second and just look at the raw, unadulterated comedy of what has happened. So, as you already know, and I've shared it before, but just laying a foundation to build up to what you haven't heard from me yet, In January, Donald Trump filed a $10 billion lawsuit against the IRS. Now, why did he sue them? Because an independent contractor leaked his tax returns. Fine. I don't blame him. Okay. That is Trump. But here's the setup. Trump's the plaintiff. That's the person who sues, files the complaint in court. And there's a defendant. You have to sue somebody who's on the other side. And that defendant is the IRS. Now, the IRS is an agency under the executive control of who? The president. Who is who? Donald Trump. Who's the plaintiff in the case? Donald Trump. So when we say Donald Trump is suing the IRS, at this point in time, he's really suing himself. Now, let's wait and think about this, okay? What? In April, federal district judge Kathleen Williams looked at this docket and essentially asked, hey, guys, quick question. How is this a lawsuit? I mean, like, where are the adverse parties? I mean, aren't there supposed to be two sides, you know? You did me wrong. No, I did not. And we now have a case or controversy, something to dispute for the judge to bring in a jury, hear everyone testify, and the jury gets to decide what they believe the facts are. And the judge, you know, reads the jury instructions before the jury goes into the back room to help them understand what the law is and what laws to apply to the facts that they, you know, decide is the truth back in the back, and they come back with a judgment or verdict. Okay. Do you realize in America, folks, you can't just sue yourself in front of a mirror and ask the taxpayers to pay for the therapy? Now, sensing that the judge was about to throw the circus out of her tent, Trump's lawyers did what any totally innocent, rule-abiding legal team would do. They quietly dismissed the lawsuit. Hey, look, we're about to get it dismissed, okay? Let's see if we can find another way to survive here. So how did they do that? Well, they settled it out of court. Now, think about that for a moment. Let that sink in. They bypassed the judge entirely, went behind a closed door, and the president settled a lawsuit with himself. No judicial scrutiny, no one to approve whether it's right, it's correct, it's the way it should be according to the law, ethics, so forth. So, new rule. If you're going to settle a multi-billion dollar lawsuit with yourself, at least pretend to negotiate. They didn't even do that. So who was at the table? Well, on one side, we have Trump's private legal team coordinated by a Boris Epstein, okay? Spelled differently than Jeffrey Epstein. Interesting. On the other side, we have the Department of Justice, run by Todd Blanche, who, up until 5 minutes ago, was Donald Trump's private criminal defense lawyer. Oh, I failed to mention Boris Epstein is Blanche's former client, too. My goodness, folks, I've seen family Thanksgiving dinners with more adversarial tension than this negotiation. It wasn't a settlement. It was a group hug that cost the taxpayers $1 billion. And what did this global settlement produce? A beautiful two-headed monster of absolute grift. First, they announced a $1.776 billion, yes, $1.776 billion, because nothing says, I'm robbing the treasury quite like a patriotic marketing gimmick. They called it the Anti-Weaponization Fund. The plan? Take money out of the Treasury's Judgment Fund, which is supposed to be used to pay actual court-ordered legal judgments, like the $140 million paid to the victims of serial abuser Larry Nassar, and instead use it to write giant checks to political allies in the January 6 rioters, whom the president already pardoned. Yes, you see, Your Honor, the Treasury is simply paying a settlement to MAGA Mike, who was horribly victimized by the Biden administration when he was prosecuted for checking notes beating a Capitol police officer with a flagpole. It's a very common civil rights claim, Your Honor. Are you kidding me? And wait, it gets better. To justify this absolute raid on the Treasury, Blanche's DOJ pointed to a historical precedent. Now, this is what I promised you. This is something I haven't shared before, okay? But my goodness, this is so bizarre, legally bizarre, okay, that Blanche and whatever you would call his legal team attempted this. They said, hey, Judge, this is just like Keep Siegel versus Vilsack. Okay, let's do a quick reality check. Keep Siegel was an Obama-era class action lawsuit. It resulted in a $760 million settlement for Native American farmers who had faced decades of documented systemic discrimination by the USDA. Look, I know history is a bit of a touchy subject for this administration, but let's be clear. A sitting billionaire president settling a sham lawsuit with himself is not exactly the same thing as Native American farmers fighting the federal government in open court for 20 years. That's right, that's long it lasted. For one thing, Obama didn't sue his own administration like Trump did. He didn't personally get any money. And most importantly, that settlement was reviewed and approved by a federal judge in open court. Blanche's deal was hammered out in secret specifically to evade judicial review. Folks, in the law, us attorneys have this, when we want to support our position and we want precedent, that is prior cases decided, we do the best we can to find a case that we call falls on all fours, like a table, 4 legs, right? In other words, the facts are basically the same. The law is the same. This is how the court ruled. Now, Judge, look at the facts here. They're just like this case. And we're dealing with the same law. So you have to rule the same way as this case because it's on all fours. What I just described to you with Keith Siegel is that it is not on all fours with the present situation that Blanche is trying to pitch to the judge. That's not on all fours. In fact, there are no fours. There were no legs. That's the circus in this, the stupidity, the legal malpractice here is to make a pitch to the judge. Oh, this is like Keep Siegel. You got to be kidding me. But the hubris here is so spectacular that it actually broke the Republican Party on Capitol Hill. When Todd Blanche walked into a closed-door lunch with Senate Republicans, he thought they'd give him standing ovation, I guess, for the 1.776 branding, 1776 with the upcoming 250th birthday of the United States. Oh, my goodness. Instead, GOP senators looked at him in scornful disbelief. They peppered him with questions he couldn't even answer, like, who's eligible for this? What are the guardrails? Are we literally writing checks to people convicted of assaulting cops? It was so bad that Senate Majority Leader John Thune halted his own party's reconciliation bill, and Republican Representative Brian Fitzpatrick teamed up with a Democrat to introduce a bill to block the funding. I mean, come on, when's the last time you've really seen Democrats and Republicans teaming up, in like the last 10-something years? When you've lost John Thune and Brian Fitzpatrick on a funding bill, you haven't just crossed the line, folks. You've run the line over with a monster truck while blasting patriotic country music. Under immense pressure, Blanche did a classic political pivot. He told CNN that the DOJ is not pursuing the $1.776 billion fund. But here's the catch. The federal judge refused to lift the injunction prohibiting the fund. Why? Because when she asked Blanche under oath if the fund was dead for good, he refused to say yes. He wanted to keep the door cracked, folks. Why? Because of head number 2 of this monster, the one-page tax immunity addendum. While the public was arguing about the 1.776 billion slush fund, Todd Blanche quietly signed a one-page document granting Donald Trump, his sons, and his businesses permanent blanket civil immunity forever from any audits or investigations regarding prior tax returns. This includes a years-long IRS audit into Trump's Chicago Tower losses that tax experts say could have cost him over $100 million. There you go. What do we do as prosecutors? We look for motive in a crime. Why did this person do that? Well, there's the motive. It's $100 million in tax liability. The IRS chief executive signed the main agreement, but when it came to the tax immunity addendum, only one signature appeared. Guess who? Todd Blanche's. You see, Treasury General Counsel Brian Morrissey literally resigned in protest the day before rather than sign it himself. Now that's an ethical lawyer. That is a smart lawyer. This Brian Morrissey doesn't say much for Todd Blanche, but it says a lot for Brian Morrissey. He knew that federal law strictly prohibits the president or his aides from directing the IRS to stop audits, which brings us back to the central theme of this entire series, the bar card. I'm genuinely, deeply perplexed by Todd Blanche. I mean, the guy is an experienced former federal prosecutor, now attorney general. He knows the rules. He had to sign a written pledge to recuse himself from all matters involving his former client, Donald Trump, which, of course, he broke that one. Instead, he becomes acting attorney general and immediately signs a document that tax experts say is flatly illegal, directly saving his former client $100 million. Under the rules of professional conduct, Rule 1.7 and Rule 1.9 strictly prohibit concurrent conflicts of interest. You cannot represent the government defending itself against your former client and then sign a deal that enriches that former client. Come on, folks. That's not rocket science, okay? That's more than common sense. It is a textbook, open and shut case for discipline, and very well could be disbarment for Todd Blanche. And then there's Rule 8.4, conduct prejudicial to the administration of justice. You see, folks, settling a lawsuit with yourself to grant your boss permanent tax immunity? Really? That is the absolute definition of prejudicial to the administration of justice. They went all the way around the court. They dismissed it with a plan, okay? A plan to deceive the court. But let me give you a new rule. Political favor is a lease to own property, and the landlord is notoriously quick to evict. Just look at his predecessor, Pam Bondi. She tried to play the ultimate loyalist game, but Trump fired her anyway because she wasn't weaponizing the DOJ fast enough to get rid of his political enemies, like the James Comey, okay, and others. And the second she was cast aside, a coalition of 100 legal scholars and retired Florida Supreme Court justice, including a chief justice, filed a devastating 23-page ethics complaint against her with the Florida bar. And now the grinding wheel of the bar is turning for Todd Blanche. A bipartisan coalition of 101 former state and federal judges has just filed a massive 69-page ethics grievance in New York seeking his disbarment. These aren't deep state actors, folks. These are his former peers on the bench. Todd Blanche is about to learn a hard, cold, unyielding truth. A president can issue criminal pardons. A president can protect you from congressional subpoenas in the short term. But a president cannot protect your law license. State bar grievance committees do not care about executive privilege. They do not care about recess appointments. They do not care about political polls or primetime television ratings. They care about a single devastating question. Did you violate your oath as an officer of the court? And once that New York bar card is stripped away, the empire of immunity collapses. The hollowing out of the DOJ, losing 21% of its veteran lawyers because honorable men and women refuse to make this trade. It's a tragedy. But the lesson of the bar card is a warning. Titles expire, administrations fall, but your bar card is your livelihood. And if you burn it to serve a temporary king, you will eventually find yourself standing in the ruins of your own career, holding nothing but a discarded license and the contempt of the profession you swore to uphold. All right, folks, thanks for listening to this episode, the last episode of the Bar Card series on Justice Redesign. Keep asking questions, keep demanding accountability, and never forget that the law still has a heartbeat, even when those in power try to stop it. I'm Steve Teskey, retired judge. This has been the Bar Card. Until next time, take care and be safe.